What is a defensive mark and how does it differ from a regular trademark? We would all be aware of what a trademark is. We see these symbols in everyday life. The TM symbol stands for an unregistered trademark, whereas an R with a circle around it is a registered trademark. A trademark is a sign that distinguishes a company's brand from other goods so that it is recognisable to the public. This sign can be words, objects, colours, shapes or sounds, but must be used in trade or commerce. But what exactly is a defensive trademark? In short, it is a mark that is registered across multiple goods and services to prevent use, even if the owner is not intending to use the mark. This stops confusion arising by customers who may wrongly associate another mark with the owner's trademark due to the well-known reputation of the original product. This piece of Commonwealth legislation, the Trademarks Act 1995, focuses specifically on trademarks in Australia. Part 17 focuses on defensive marks and Section 185 defines the grounds for applying for a mark. A defensive mark intends to prevent trademark infringement. Here is a simplified version of Section 185 of the Act. The requirements to apply for a defensive mark are: first, the applicant must have a registered trademark. That trademark has a considerable reputation. The use of that trademark by another is likely to infer a connection with the original trademark. And finally, the applicant must prove with appropriate evidence that a defensive mark is justified. Let's have a look at some of the companies that have a defensive trademark. The Coca-Cola company is one of the most recognisable brands in the world. Coca-Cola's leading product, Coke, is a variety of soft drink, but cola itself is merely a style of drink and not trademarked. Coke, however, has been defensively marked. This protection extends to other classes of goods, such as lollies, cakes and soft drink, to prevent similar marks that would likely cause people to mistake those goods as being associated with Coke. This is a bottle of cola produced by Regal Soft Drink Company. This sign would not be infringing Coke's defensive mark, as a person would be unlikely to infer a connection between this product and Coca-Cola. The average person would see this simply as a competitor's product. There are a few key differences between a defensive and a standard trademark. One of the prerequisites of a standard mark is that the registration only provides 10 years of protection, and renewal is dependent on the continual use of the sign. Comparatively, with a defensive mark, you needn't even intend to use the trademark, as it is merely there to prevent others from distinguishing their goods in a way that could be confused with the applicant. Coca-Cola's protection extends to Class 30 goods, which includes cakes, bread, and condiments. Even if Coca-Cola did not intend to produce one of these goods, if another company branded their product in a way that would be misleading to the public, it would be in violation of IP law. Next, only the very well-known marks are eligible for a defensive trademark, and examples of other companies that are protected include Kleenex, Holden, Sony, Bonds, and Gillette. And finally, the process to be defensively marked is long and stringent, and the onus of proof is on the applicant to provide enough evidence that their mark is of great reputation in Australia and of the highest distinctiveness. In summary, defensive marks are a form of trademark, but are intended to provide an extra layer of protection for well-known brands. They seek to prevent misleading and deceptive conduct in trade or commerce by prohibiting signs that would infer a connection with another. This upholds reputation, promotes uniqueness, and maintains distinguished trademarks. Without defensive marks, companies like Coca-Cola would lose commercial worth and not have such a strong hold on the cola industry. I hope you have learned a thing or two about defensive marks. Thanks for listening.